the whole truth and nothing but the truth, so help you God.
I swear, Your Honor.
Opening statement, please, sir.
Yes, Your Honor. We'll be reciting a proposed agreed order regarding child support and retroactive support. And we're asking the court to make a determination as to what the visitation schedule should be. I believe the children in this case are 3 and 1, and the custodial person is requesting that there be supervised visits that appear to be indefinitely or at least not defined as to when they would end. And Mr. Clarity is asking that there be at least some sort of gradual schedule.
Okay, good enough. Call your first witness.
If I could, before I call witnesses, Your Honor, may I just recite the proposed agreement?
Yes, sir.
Your Honor, the parties are in agreement that Mr. Clarity would pay child support of $627 per month with a step down to $502 when it's one child only, that there would be a retroactive support judgment of $1,358, and that would be paid at $53 a month. So the total is $730, or about $168 and some pennies a week. And those would all start on November the 1st. And Mr. Clarity, is that your understanding of the agreement?
Yes, yes, sir.
And Ms. Morgan, are you in agreement with those terms?
Yes, sir.
The state, oh, go ahead, Your Honor, I'm sorry.
What about medical?
Oh, I apologize, $50 for cash medical support, and mother would provide that through government source.
Okay, thank you. All right, proceed.
Thank you. State calls Destiny Morgan. Ms. Morgan, can you hear okay?
Yes, sir.
So your children, Emma, she's 3, and Kason, he just turned 1, correct?
Yes, sir.
And has there ever been any family violence between you and Mr. Clarity?
Quite a long history, sir.
And let me ask you this. When was the most recent time that something happened between y'all?
June, around late June when he left. He had been drinking all night and we got into a physical altercation.
And was law enforcement involved?
No.
Before that, was there a physical altercation?
Yes, sir. I do believe in early 2022, I was living in West at the moment, and we had an altercation at the apartment that I was living in. It resulted in me getting evicted.
Does he know where you live now?
Yes, sir.
And y'all lived together until when?
Until late June of this year. It's been on and off living together.
And have you seen Mr. Clarity drinking excessively?
During the time she's lived with me or here lately?
Well, first of all, during the times that you lived together.
Yes, sir.
Do you believe, were you drinking at the same time?
No, sir, I didn't drink.
And have you seen him since y'all separated?
No, sir.
Do you still take the children to see his family?
Yes, sir. Almost every weekend.
And is he ever there during those times?
No, sir.
Do you get along okay with his family?
Yes, sir.
Would you feel comfortable if you continued to take the children over to their place?
Yes, sir.
Can he go to their place?
No, sir. He has a criminal trespassing warning on that property now.
Do you have any proposal about how visitation might occur where he can be with the children in a particular place, but yet still have someone supervising?
If we could talk to his family members and see if they'll do supervised visits out there, or maybe somewhere in the public, where just out in the public, I
Okay.
guess.
So you would be fine with anyone in his family also supervising if you didn't want to be the person, correct?
Yes, sir.
Okay. What health insurance do the children have right now?
They have Medicaid through Superior.
And do you think that you and Mr. Clarity can talk with each other or text each other about making decisions about your children going forward?
Yes, sir.
And I'm sorry, was that a yes or a no?
Yes, sir.
Have y'all been talking for the past 2 months?
Not very much, just one or two texts here and there.
Has he asked you by text about the children in the past 2 months?
He has asked a few times. Yes, sir.
Have you ever blocked him where he can't get in touch with you?
The most he had gotten blocked was about five minutes just for the conversation to cool down. But immediately after that, he would be unblocked just in case he tried to get in contact with the children.
So do you think that Mr. Clarity has a problem or issues with alcohol that are impairing him and being a parent?
Yes, sir.
And can you tell the court things that you have seen, not that other people have told you, but things you have seen? Is there anything else you think the court needs to know?
Besides, whenever he is drinking, he'll get to the point where he starts to fight with me, or if I'm holding one of the children, he'll be yelling in my face. He's knocked our 1-year-old down a few times whenever he was trying to stand, saying that he'll toughen him up, and being that that's a 6-month-old baby, there's no need to be knocking him down on purpose. There's just been so many times where his drinking has caused him to get violent. Other than his drinking, he's really a good person.
You're asking the court to have some initial supervision of the visits. What do you think Mr. Clarity needs to do, or what are you asking him to show the court where he would not be supervised anymore?
No alcohol.
Okay. We'll pass the witness, Your Honor.
Mr. Clarity, do you have any questions for Ms. Morgan?
No, Your Honor.
Ms. Morgan, do you have any reasonable fear or concern that if your contact information is included in this order, you or the child might suffer harassment, or you or the children might suffer harassment, abuse, serious harm, or possible injury?
No, Your Honor.
Your current living situation, are you in a apartment, a house?
I'm in a house. I live with my mother and my father.
And other than you and the children and your parents, does anybody else live there?
No, sir. They all moved out, I think September.
And who were they?
It was just my older brother and then my younger sister.
Okay. And you and your children, do your children have their own room, or do they share a room with you?
They do share a room with me.
And you have your parents there. You're able to get the kids where they need to be.
Yes, sir.
appointments,
Yes, Your Honor.
Has CPS ever been involved in your business?
No, Your Honor.
All right. Anything else for this witness, Mr. Steinke?
No, Your Honor.
All right. Call your next witness.
State calls Jacob Clarity. Mr. Clarity, have you been prevented from being able to see your children since y'all separated?
Yes, Your Honor.
And can you tell the court how that has happened? What has gone wrong?
She would tell me no, and she would not let me come get them or come see them. I've tried to FaceTime a few times just to see them. She's always tried to tell me she's busy or something like that. We do it later, but when it come to later, she would just never do it.
Now, you do not have any other children, is that correct?
Yes, sir.
What is going on where you're not able to go back to your family's house?
I just got into an argument with my grandparent or my grandma, and she did not like something I said, so she called the cops and had me leave.
And so to your knowledge, you're not able to go onto that property.
Yes, Your Honor. Or yes, sir.
Okay. And do you feel like that your drinking has had any impact on you and interacting with people?
Not lately, Your Honor. No, sir.
Okay. And I appreciate the courtesy, but you don't have to refer to me as Your Honor. I know that this is different for you, but it's only for Judge Arian, but thank you.
Yes, sir.
So what do you think has changed?
Recently I've just stopped drinking as much and just let it go.
Now, did you go to a parenting class?
Yes, sir. And I'm also doing an alcohol and drug class online. I have a 4-hour badge that I can print off too.
So you completed a parenting class. Do you know what the name of that was?
I can go get the paperwork on the other desk real quick if you want me to and look at
No,
it.
that's okay. You just mentioned it to me. Do you have any probation or parole or anything going on right now?
No, sir.
So most people are not that responsible to go do those sorts of classes unless someone says they have to do it. Why did you decide to do the parenting class?
Just because I figured wouldn't hurt to do it. It would probably help in this situation. Same with the alcohol and the thing.
Okay. And if there were restrictions put on by the court, for instance, that said that you're not supposed to drink before you go to be with the kids or while you're with the kids, is that something you feel like you could do?
Yes, sir.
Have you ever been charged with DWI?
No, sir.
Do you think you and Miss Morgan can talk with each other about how to raise the kids going forward?
Yes, sir.
Does she know where you're living right now?
I don't think so.
Can you provide the address for where that is?
It's
And where's
Elmont,
that? In Elmont?
Texas.
Okay.
Yes, sir.
Who else lives at that residence?
It would be my girl, her dad, and her brother.
Okay. And when you're referring to your girl, is that your girlfriend?
Yes, yes, sir.
Okay. Okay. To your knowledge, has there ever been any CPS investigation of the people in that home?
No, sir. Not to my knowledge.
Those are all the questions that I have, Your Honor.
Ms. Morgan, do you have any questions for Mr. Clarity?
No, Your Honor.
Call your next witness, Mr. Steinke.
Your Honor, the state rests.
All right, then. The court approves the agreements of the parties with regard to current child support at 627 with a step down to 502. Retroactive judgment of $1,358 is entered to be paid at $53 a month. The children will remain on government medical, $50 a month cash medical support. The court is appointing the parents joint managing conservators. The mother has a right to establish domicile. One other question, Ms. Morgan, without giving me an address, do you live in Hill County? Do you live in McLennan County? Where do you live?
I live in Hill County, Your Honor.
You do? Are you close to Hillsborough?
Yes, Your Honor.
Okay. Yeah, the mother has a right to establish domicile without regard to geographic location. The court is going to order some phased-in visitation. The family code says that for children under 3, I'm supposed to order special visitation to allow them to get to know the non-custodial parent and to bond with them before they're going overnight. So we don't want to traumatize children. So we're going to start out on the first third and fifth Saturday of the month, beginning at 1 p.m. and ending at 4 p.m. Mr. Clarity will have the opportunity to see the children. These visits will be supervised initially by the mother or another competent adult that she designates. That can be his parents, it can be anybody, but it's somebody, it's your discretion, Ms. Morgan, who supervises. These visits are going to take place in a public setting. I'm going to say, I don't know if there's a playscape at the McDonald's off of I-35 in Hillsborough or not. But I'm going to go ahead and order that y'all will meet at the McDonald's in Hillsborough. And the visits, y'all can choose to go somewhere else once you meet there, but that's where the meetup place is going to be. Supervising, Ms. Morgan, doesn't mean that you're there to tell them what to do. It means that you're there so that the children know that somebody they recognize and somebody that, they know is there, so that if they, they're playing with dad and then they decide they want to see their mom, they just walk over to you. It's not a situation where you're pointing out or explaining or dictating what goes on. I don't like the word supervised, or supervision, but I don't know of any other word that works any better. So that's what that means. Mr. Clarity is prohibited from consuming alcohol or controlled substance without a prescription for 12 hours prior to or during any period of possession. And he's give Ms. Morgan 48 hours notice of his intent to visit. So just text her or something like that and say, I'll be there at 1. And that's all you have to do. We're going to go ahead, and because of the younger child is just 1, we're going to do these visits. We're going to do 20 of these visits. After you've completed 20 supervised visits, we're going to go to first, third, and fifth Saturday from 1 to 4 p.m. unsupervised. Y'all will meet at McDonald's. All the same notice provisions will take place. We're only going to do 10 of those. Then it becomes the first, third, and fifth Saturday from 8 in the morning to 5 in the evening. Those visits will, again, you'll meet at McDonald's, same notice provisions and everything. Those visits are unsupervised. After that, we'll do 5 of those. Then we'll do 5 overnights from 6 p.m. on Saturday to 6 p.m. on Sunday on the first, third, and fifth Saturdays of the month. All the same notice provisions, etc. And then after we've completed 5 of those, standard possession order will go into effect. The purpose of this is not to punish anybody. The purpose of this is to let the children get comfortable with you, Mr. Clarity, particularly the younger one. A 1-year-old, doesn't have a lot of memory and things like that. So we want the younger one to grow up, get older, and become comfortable with you. After that, as I said, a standard possession order will go into effect. And that's the first, third, and fifth weekends of the month from 6 p.m. on Friday to 6 p.m. on Sunday. And then there's other visitation during holidays and things. Non-disclosure is denied. Mr. Clarity will pay court costs if he's billed for them within 1 year of the date this order is signed. Mr. Steinke will prepare this. He will send it to each of you via DocuSign. You'll get an email, and the order will be in an app called DocuSign. You can open it up. If you have a touch screen device, you can scroll through it using your finger. If you don't have a touch screen device, you can use up and down arrows or a mouse, and you can sign it. If you have a touch screen device, you can sign it with your finger. If you don't have a touch screen device, you can opt for an electronic signature. But in either case, on the last page of the order, there'll be a button that says finished. Once you've signed the order, tap finished, and the order will go back to Mr. Steinke. And he'll present it to the court. You each have the right to appeal my decision, not with regard to the matters that were in agreement, but with regard to the visitation schedule. If you wish to appeal my decision, your appeal must be in writing. You have to write down what you disagree with and why you disagree with me. And then once you've done that, take the original and multiple copies and file it with the district clerk in Hale County, Texas. When you take it in, give the clerk your original and multiple copies. The clerk will keep the original and will date and time stamp the copies and return them to you. When that has occurred, it will be your responsibility to get a copy of that paper to the other party and to the Office of the Attorney General. Having done that, it will become, it is incumbent upon you then to get in touch with the coordinator of the county court at law to arrange for a new hearing in front of Judge Crane. And then you'll have to send out notice of that hearing. You have 3 working days from the day I sign this order within which to file your request for what's called trial de novo. De novo is just a Latin phrase that means new. Today, get the calendar up here. Today is Friday, the 20th of October. Assume that I'm signing this order today. In all likelihood, I'm not going to, but assume that I am. It doesn't hurt you to file early. So today is Friday, Saturday doesn't count, and Sunday doesn't count because those are not considered working days. Monday, the 23rd of October is the first working day. Tuesday, the 24th of October is the second working day. Wednesday, the 25th of October is the third working day. You have until the close of business on Wednesday, the 25th of October, 2023 to file your request for trial de novo. If you miss that deadline, my decision becomes final, and it will remain so until the order is modified in future litigation. Does anybody have any questions?
No, Your Honor.
No,
No, Your Honor.
Very good then. Good luck to y'all. And unless there's something else, we are off the record.